We are live. I have the lovely Kailey Jacomet here. Kailey is an incredibly bright lawyer who has really helped my business over the years as a lawyer for our company, but also she is just a wealth of experience. If you are an online business manager and have a client who is interested in trademarking or any kind of online legal stuff, I will let Kailey introduce herself so she can tell you the full gamut of what she does as a lawyer. But Kailey, are you still mainly a trademark lawyer?
Mainly, yes. Yeah, thank you for that introduction. Yeah. So I have a trademark practice where I primarily practice trademark and copyright law. Then I also have a contract template shop. So those are digital products and contract template shops for service providers. We also have membership terms and conditions, speaking engagement contracts, pretty much anything you need in terms of contracts, being a online business owner and or service provider. So that's what I do. I know that, Sarah, in your community, you have people all over the world, and they're probably at different stages of their business journey. So therefore, their legal needs may be different. I am a US trained attorney. However, a lot of what I'm going to talk about, though some of the details may vary, are fairly consistent, throughout jurisdictions in the EU, Canada, Australia, even Israel. And so specifically a lot about contracts are going to be fairly consistent. There are some things that change, but in the realm of being an OBM as a retainer service provider, a lot of that is going to be the same. So I have a couple questions that came to mind that are frequently asked questions. Sarah, should I dive into those first?
Yeah, I see we've got, so I actually also, before we kick off, I want to give a couple things. One thing is that Kailey has this incredible OBM legal templates that she prepared, not just for us, but for OBMs in general, that she is lovingly giving us 30% off for our community with the coupon code OBM30. So I've left the link in the comments. And I also just wanted to remind you guys, as I know we have quite a few people on here listening, that our applications for OBM accreditation over at obmaccreditation.com are still open. I know we have a few of you guys here in the comments from the program, but our applications are still open. Early bird is still on. So you definitely want to head over to obmaccreditation.com and check out the legal bundle as well. Okay. So let's get,
Awesome.
So if you guys want to leave your questions in the comments, feel free. We do have some questions that came in that, are sort of the common ones that we have time and time again, because lucky for us, Kailey comes into our community from time to time, which we're really grateful for. So let's get right on into it.
Okay, yeah. So first I wanted to start with just the disclaimer of this, of course, is not legal advice for anyone in particular. It's educational information. So there can be different circumstances that will change these answers for some people. But Sarah, do you want to just start off with those questions, since that's what the people want to hear? Yeah.
Let's just do it. I know you sent them to Toby. I don't see them on the prep sheet. Do you have them in front of you there?
Okay, I didn't know if you No, that's fine. No worries. So first, a lot of people ask, do I need to become an LLC? So if you don't do anything to register your business, automatically you're a sole proprietor. Now, depending on what jurisdiction you live in, you may have a requirement to register your business, but that doesn't mean that you're forming a separate type of organization or business. You are still a sole proprietor who's just, registering in your county or your state or whatever. Some places don't have any requirement for you to register your business. However, what makes you a sole proprietor is just offering your OBM services in the marketplace in exchange for payment. So if you're doing that and you haven't taken any additional steps to form an LLC, in some jurisdictions that's called a limited company or a corporation, then by default, you're a sole proprietor. Now, the benefits of just using that default structure, being an individual service provider, is that you don't need to pay to form a limited company or LLC. So there's no barriers. It's just you know, getting your first client. And we know all how easy that is, right, Sarah? So that's just your automatic form of business. Then if you were to create an LLC or a limited corporation, the advantage of that would be you would be separating your own liability from the business's liability. There are also tax considerations in making this decision. So while I'm not a tax professional, I can speak to this a little bit generally. And this is going to be very specific for how much revenue you're bringing in, what your household income level is. But what I want to say is when it comes to the legal side of should I be a sole proprietor or an LLC, it doesn't hurt to go ahead and form your LLC. It's only going to give you advantages. In the United States, in most jurisdictions, it's around the $100 mark, usually between 80 to 140, depending on where you are, to form an LLC. And then each year, you will have to file an annual report, which is very simple. It's you'll just be asked a few questions. In most jurisdictions, it's an e-filing, and then you will have to pay a renewal fee. So again, that varies. I would say it's at or around the $100 mark each year to maintain your LLC status. And from a legal perspective, this is going to help you so that if your business is sued, let's say, I don't know, let's say you are accused of copyright infringement in something that you put together for your client, and now your client is being sued, and now your client is looking to you to recover damages from you for what you did, which caused them to be sued. There are many different scenarios that can come up. This is going to shield your personal finances, your personal assets from liabilities of the company. So they can sue the business's assets, but they can't come after you personally and your family's finances. And a lot of people forget that the same, you know, it's vice versa. So let's say you are sued personally because you were in a car accident and you were negligent, and now you are being sued. If you are a sole proprietor, the business's assets are your assets. There's no separation there. So your business assets could be taken to satisfy a judgment against you personally. So that's the legal side of things. I would say there's no downside at all to forming an LLC. It's very simple to maintain your status if you can fit it in your budget. However, the real legal protection in your business as an OBM is your contract. So don't think, you know, now that I'm an LLC, I'm good and I don't need to like worry about legal liability, because your contract protects you way more than your LLC status. And you could be a sole proprietor, you could be an LLC. There's not necessarily a wrong answer, but you absolutely need a contract. That's your legal protection. And we'll get into that more. On the tax side of things, when it comes to being an LLC, and again, this is going to vary depending on where you're located versus a sole proprietor, is in the United States, there is a kind of a penalty sort of tax on self-employed individuals who are sole proprietors, because the wonderful IRS treats you as an individual as if you are the worker and the employer. So it's taxing you as you're the employer and the worker. So at some point, there's a bit of a double taxation there. Now, you can potentially save money on taxes by becoming an LLC. And then when you're an LLC, you can choose. So now we're over in the LLC. I'm using my hands. I don't know if anyone's just listening to this, but I talk with my hands. You have an LLC. Now, for tax purposes, you have two choices. You can elect to be treated still as an individual for tax purposes. So you'll be treated just as if you never formed that LLC for tax purposes, or you can choose to be treated as an S Corp. You're not a corporation, you're still an LLC, but you're choosing to be treated as an S Corp for tax purposes. Now, when you choose to be treated as an S Corp, that will come with more paperwork. Now you have to pay unemployment taxes. You have to put yourself on payroll. There's a lot of administrative stuff that makes it more complicated and can create an expense. However, you get rid of that situation where you're kind of being double taxed. And if there's any CPA listening, they're probably like, Kailey, it's not a double taxation, but you get rid of that penalty of being taxed as the employer and the employee, because you can deduct half of that now. So all of that to say, there is a certain income level. It's not a science. You really need to speak with your accountant and your CPA, where when you start earning a certain amount of money in your OBM business, you really want to look at, am I going to, even after I put myself on payroll and get help from an accountant, am I going to save so much more on taxes now that it's worth doing that? And what I do find is a lot of people, they, even if they become an LLC, they initially choose to be a sole proprietor, which can be correct for tax purposes. So you formed an LLC, but you're choosing to be treated as a sole proprietor for tax purposes. And initially, that might be the right decision for you mathematically. But a lot of people don't update that to S Corp election when they start making more money. And again, this could, for some people, this could be around the $50,000 mark, that you are now at a point where you're going to save money paying for payroll and doing these other things, but you're going to save more on taxes. So each year, I think it is prudent to check in with your CPA, whether you're a sole proprietor now or LLC, and see, is it time for me to go with S Corp tax election? Again, that was very specific for you OBMs in the United States. So legal perspective, doesn't hurt to be.
We've got some juicy
now,
questions.
Okay, love it. I'll let you interject, Sarah.
Okay, so here's one of them. This is Vibke. Vibke is, I guess Vibke, is your business registered in the States? I know she's German, but lives nomadically. Well, she's in Chile now, so she's in South America. She's wondering about how she can protect her business in case one of her contractors makes a mistake that causes a financial loss for a client. Or what you just mentioned about, what if my client is being sued because of something my team did wrong? Or is that more of a liability insurance thing? Yeah, she's got a US LLC, she wrote. Yeah.
Okay. That is going to be primarily a contract issue. Now, when it comes to liability insurance, there's error and omissions is probably the most popular and relevant type of insurance for service providers. What I will say about that is you need to be really careful to read the terms and conditions, and understand what scenarios you're going to have coverage and what scenarios you're not going to have coverage for, because sometimes that can be like, you have homeowners insurance, your basement floods, you assume it's covered and it's not covered at all. That can happen a lot with error and omissions insurance. So your primary, you don't want to rely on that even when you do have coverage. You want to primarily rely on your contract. And so if you have, you want to have two contracts here. You need a contract with your contractor, with your team members. So when you have a relationship where you are hiring someone as a subcontractor, they could be the one providing the contract to you to sign. So as an example, let's say I'm an OBM and I have virtual assistants that help me to do the work to deliver my services to my clients. I might hire someone who's a VA and they present me with their own contract to sign. I'm almost always going to prefer that I provide the contract to my VA to hire them, because yes, you want your contracts to be fair and balanced for all parties, but the drafting party, so the person who is the one initially providing the contract to the other to sign, you're always going to have language that's more favorable to you. And so that would be, in general, my preference is to provide the contract to the subcontractor. And within that contract, you want to have what's called an indemnification clause. So indemnification means if you do something wrong, if you make a mistake, and someone is blaming me for the mistake you made. And so in this situation, it's the VA makes some kind of mistake, that product or whatever deliverable is sent over to the client of the OBM. And now the OBM is being sued for a financial loss of the client. The indemnification clause is VA, you agreed that if this happened and it was your fault, you did the thing that caused the financial loss to happen, that you were going to step into my shoes and take the blame for it. So it's a clause where you're saying you're going to indemnify, take the blame for it, and hold harmless. So that's one thing. That's one contract that you want to have. And then the other contract that you want to have, and of course, that's not the only clause that you need in your contract with your subcontractors. That's just the one that is most relevant in this scenario. And then you want a contract that is with you and your client, of course. And also, there's a whole bunch of clauses that you want in there. The one that's most relevant in this situation is your limitation of liability, because you don't only want to rely on that indemnification clause. You also, in your relationship with the client, want to have a limitation of liability clause. And that means even if I mess up or one of my subcontractors mess up, within that relationship, you can't necessarily say, oh, it wasn't me, it was my contractor. You have to, only deal with my contractor. That exchange of liability or taking the blame of that happens in your contract with your subcontractor. But over here, again, using my hands, your contract with your client, limitation of liability means even if I or one of my subcontractors make a mistake and are negligent and mess up and cause you to experience a financial loss, my total liability, our company's total liability, is going to be limited to a certain amount. And most often that will be your monthly retainer. So whatever let's say your monthly retainer is $2,000. That doesn't mean that any mistake you make, you're going to owe your client the $2,000. They still have to prove what their damages were. But if their damages are $10,000, the amount that they are able to recover from you is $2,000, the amount that is in the limitation of liability clause. So that is that relationship. And then you would have to recover that $2,000 from your subcontractor, pointing to your indemnification clause.
So Vipka followed up and she wrote, I don't know if this is still relevant. She wrote, I'm not sure if I understood the part step into my shoes and be blamed for it, meaning the VA would contact my client and identify themselves as the culprit. It feels odd, which I feel like you've addressed just now.
Right. Yep. So no, it would be kind of two separate things here. Actually, this gets a little bit complicated. If you were actually involved in litigation with your client, then yes, they could be added as a party to the lawsuit. But it's not that they need to that they're going to proactively knock on their door. There'd probably be a lot of things going on here. Demand letters, probably at least 2, maybe 3 lawyers involved if it's getting to the point where someone has actually threatened a lawsuit. So in the logistics, that could get a little complicated because they could be added as a third party. But to just simplify it, it also could be that your company owes $2,000 to your client, and then you're going to separately recover that amount from your VA. It could play out in different ways.
Yeah. And I think Ramona followed up. I don't know if this is relevant. Is E&O exempt needed, or is that covered under indemnification? Now, Ramona is in Canada. I don't know.
So that's just different. So the E&O insurance is different. And a lot of people do ask me insurance questions. I'm not an insurance expert, but what the insurance is going to cover is when, so you have your contract, which is going to say what you were responsible for, what you owe, what you don't owe. So again, that either whether it's the indemnification or it's the limitation of liability, no, I don't owe you $10,000. I only owe you $2,000. Now, how do we pay this $2,000? Maybe the insurance will cover it. Does that make sense? So the insurance doesn't make you not responsible to your client. It helps you to pay that.
Yeah, she gets it now. Yay. Okay, another question came up from the lovely Kristen. Hey, another accredited OBM. I plan on doing this right, but I'm just wondering, why is it important to have a lawyer write up my contracts? Why couldn't I do it myself? Thank you, and thank you for the generous discount.
Thank you, Kristen. I feel like you're just giving me like an underhand softball, and I'm all teed up to like easily hit this one. Yes, why is it important to have a lawyer write your
Yeah, I
contracts?
will say here, you definitely wanna have your lawyer look at this. You definitely need a lawyer, like, from Sarah's perspective, but I'll let Kailey take it away.
Right, right. So, why is it important to have a lawyer write contracts instead of just writing them up yourself? So let's say you were going to write it yourself. Probably what I imagine you would do is you would probably like Google a free template, like different contracts that you can pull up on the internet. And you would either just, go with the totality of one that you find, or you might mix and match. You're like, oh, that one has,
Mhm.
that seems like a good idea to put in. The problem is that you don't know what you don't know. And if you handed me like a scientific journal on, like, I don't know, physics and black holes, I would read it and it would not be my area of expertise. It would sound impressive to me. It would probably sound like, yeah, that sounds right. That sounds accurate. I would be impressed by it. And I would have no way of knowing whether it was incomplete, it was incorrect, because that's not my area of expertise. So I think that's the problem especially when you're dealing with legalese, you don't know if your contract is going to have everything
Yeah.
in it. You might not be well positioned to assess whether one part of the contract contradicts another. And I would say the biggest area is the gaps. The other thing is, not every service provider contract is right for every service provider. So if you are a coach, that's a lot different than being an OBM. And even a VA and an OBM might be more similar in some of their deliverables. You have a lot more responsibilities as an OBM, and there are things that you want to make sure that you address, like what your authority as an OBM is, what your authority is or isn't as an agent of the company, as a manager, things like intellectual property rights and all of that. So I would say that the biggest pitfall is that you don't know what you don't know, and you want to make sure that it's really tailored to OBMs.
Yeah, and here's Ada, who's I'm not gonna get into details here, but what happens when it's worst case scenario and you might be held legally liable for any financial loss. I have a contract section with liability, but I made it myself. So this really feeds into what Kristen's saying. Not sure how tight it is. Also not sure how to help without taking on any blame myself. Also a good point.
Okay, so I'll start with the first part of that. So when it comes to contracts that you already have with a client, like you have an existing client and you already have a contract with them, then that's what controls. You could always ask your client, I have a new contract. Would you sign it? And then it's up to them whether they want to or not. If your contract term, hasn't ended yet.
Mhm.
But I would say that certainly with any new clients, make sure that you do have full confidence in the
I got a
contract that you
2024 contract, guys. It's, like, slightly updated. You can always,
right.
come on, guys. We got some good skills, some good soft skills. You could get that in easy.
Yep, yep. I think that's a really good point. Even if your term ends in June,
Mhm.
you can they can always say no. If they say no and the contract term hasn't ended yet, there's nothing that you can do about that. But I think that's a very smooth transition, Sarah, to say, "Hey, I've spruced up the contract," and you can say, the all of these the scope of services and payment details and all of that are the same. There's just some like additional legalese or whatever, like, or you can even say here are the sections that I've updated after speaking to my lawyer. And probably very few clients, if you're making changes like that where you're just updating the language and making it more legally enforceable, are going to say no if it's not changing the transaction necessarily between the two of you. But certainly for any new clients going forward, you want to have full confidence in the document that you're sending over to them. And then this last part, I'm not sure how to help without taking on any blame myself. Ada, did you mean by that, like but you want to bring it up, but you don't want to point out that maybe you weren't fully confident in the liability clause.
I think I can sort of fill in the blank here as a people pleaser myself. It's like, even if you find that you're like not responsible for something, it's hard not to take on, because
Okay.
we OBMs are accountable, responsible human beings. It's sort of part of our DNA. So, I mean, like, obviously, I'm the first to say that crazy legal things happen. You know, as someone who's been in business for 15 years, yeah, crazy legal things happen. So you don't want to be caught in a bind. No pun intended. So yeah, so you want to have some solid contracts. You want to definitely leave it to the pros when it comes to the legalities. Yeah. They're asking for details on what happened. Yes. Also, she lives in Canada. Lots of Canadians on today. Hey.
I would say, as someone who obviously has clients and has team members, and I'm sure you can agree with this, Sarah, that as a client, your client would be more disappointed by, when you're explaining what happened, more disappointed by dishonesty than you making a mistake, because everybody makes mistakes. That doesn't mean that they're going to completely forgive you. But if you add to that, when people try to not
Yeah,
be forthcoming about what
yeah.
happened, adds a whole other layer. You can still love a person who makes mistakes. Maybe they'll fire you, but they can still love you for a
Right,
distance. They will not
right,
love you so much if I'm
right.
not saying that Ada, you would be doing that, but I think the other thing is, this is a little bit an extra tidbit. This is just my personal, style, and it probably comes from, being an attorney. But whenever you're explaining yourself, make it really short, to the point. If you have 3 paragraphs, bring it down to 1. Tell them, like, the what they need to know, and an apology. And I think that's, whenever you're dealing with people conflicts, it's just
Mhm.
very good to be concise and to the point.
So, Beth is looking at the bundle. Hold on, let me just have a look. This is the code. It's obmschool.com / legal dash bundle. So there's different, obviously there's the bundle of everything. So you have various different agreements. So the 30% off is for any of these agreements. Yeah. So the link works.
Okay, just to go over what is included.
Yeah.
So you have 2 different standalone contracts. The OBM retainer agreement, and so that's if you have like a 6-month-long contract or a 12-month-long contract, and you are on retainer. The project would be if you're coming on, like, let's say someone is making this up. Let's say someone is hosting a virtual summit, and you're coming on as the OBM to manage that project, and you're not a regular retainer OBM or something like that, then you would want that project agreement. Then you have, like I was mentioning, the hiring agreement. This you're welcome to use in your own business, and you're welcome to use this in your client's business, or provide it to your client. And that is when you are hiring a subcontractor. So again, not every subcontractor will be willing to sign a contract you provide them. They may say, no, I have my contract. And then you can choose whether you want to move forward with that or not. But generally, it's much more favorable to be the drafting party. And then finally, the bundle has all of that together.
Yeah.
So maybe we can, if there are, let's see.
Yeah.
How
So
helpful is
Shnavi,
someone who
yes.
is okay. So I am not familiar, with the specific laws in India. I will say, in my knowledge and experience, most of the clauses in a service contract are transferable to other jurisdictions. But if you are not in the United States, then you may want to, if you do get one of the templates, have an attorney in India read.
Sorry, you want me to pull it up again?
Okay, yeah. And did that answer your question? So I would say to have, to have an attorney in India review it for you.
Definitely. Okay, guys. Anyone want to post some more questions in here? If not, we'll sort of continue on with what we've prepared. Go on for another little bit here.
Okay, sure. So we kind of touched on this, so I'll just answer it quick. But I have a lot of people ask, can I just use one of the service contracts that's in Dubsado or Honeybook? And I think Honeybook, there are service contracts that are provided, and I would imagine that they were probably written by a lawyer. The problem with them, though, is that they're extremely bare bones. They're very just your nuts and bolts boilerplate contracts, and like I mentioned, a coach is going to be very different than an OBM in terms of the services they provide and how you want to enforce those and what you need to protect yourself from legally. The same is true of using these boilerplate contracts. So they don't distinguish between what kind of services you're providing. So you definitely want to have a contract that is specifically geared towards OBMs. And then another question that I do get asked a lot is and this has seemed to happen a lot recently to people I know, but having a client who cancels right before their payment is due. So they have a contract, and usually I would say the standard is, if you are on a retainer, is a 30-day notice period. You could extend that to 60 days. I think that much more than that probably would be impractical, or not reasonable rather. But 30 or 60 days is a reasonable notice period. And I have seen a lot of people who, even though they have a notice period, their client is not respecting it. And they are canceling like halfway through the month, or they send out an invoice. And when they receive the invoice, it's probably because they're having, hard financial times. They say, oh, I don't want to move forward next month. I want to cancel. And the whole point of your notice period is so that you have a little bit of buffer room here to go back and try to, recruit another client. If you're a fully booked out OBM, which you will be working with Sarah, then you might not be as aggressively marketing all the time as you were when you first started your business. And so you want to have some notice time so you can go back. And I'm sure, Sarah, you teach having like a consistent stream of leads, but it's very,
and that pipeline full. Oh, you know it, Kailey.
Yeah. So, but a lot of, many of us don't perfectly practice, what we know we should be doing. And you want to have a little buffer there to onboard a new client. Because as an OBM, your retainer agreements are probably somewhat significant. It's not like you have 15 clients. When you lose one, it can really be a hit to your income.
25% of your revenue. Yes.
Right. Now, okay, but let's say that's the situation you're in. You had that notice requirement, but they're canceling. So first, I would recommend that you, of course, you deal with that yourself by responding to them and citing your contract language. Because I think a lot of conflicts are born through misunderstanding, and it's very easy to get defensive and think, oh, they're trying to get out of not paying me or not giving me notice. So just treat it very professionally. And that's the nice thing about having a contract. Even if you're a people pleaser, you can very matter of factly say, I'm sorry to hear that, insert, blah, blah, blah. As per section here of our contract, your invoice is due by this time, and I'm happy to, continue supporting you when you're ready, to move forward again. Now, if they say, no, I'm not paying for another month or whatever, then I would come back and reinforce the language in your contract. And then maybe you can say, I can extend the deadline by 2 weeks, but be firm and be concise and keep citing your contract language. There will come a time, if this person just still refuses to pay, that, these efforts are becoming futile. And then what do you do? So then you need to decide whether it is financially worth it, depending on what the retainer amount was, to get legal help with the situation or not. So if you were to retain the help of a lawyer, that should be a lawyer who's in your jurisdiction. And the first thing that they're probably going to do is send a demand letter. And sometimes that really does the trick. And depending on what your retainer amount is, that might be a worthwhile investment. And so I can't say what an attorney in your jurisdiction is going to charge for that. But let's say your retainer fee is $2,500 and they're going to charge you less than $1,000 to write this letter. And otherwise, you're not going to see this money. Your efforts have not been successful. It might be worthwhile doing that, because when it comes to copyright infringement and trademark infringement, I deal with that all the time. I have a lot of clients who have reached out to people who are ripping off their name or ripping off, whatever it is, their original content. They've sent them emails, they've sent them, Instagram messages, Facebook messages. They are telling them to go take a hike. They do not care. They're ignoring them completely. And then when I send a cease and desist letter, not every time, but a lot of the time, they immediately comply. Or the next day or the day after, I will get a letter back from their lawyer, which I actually like to see, because that's the thing. When someone gets a legal letter, sometimes they will say, uh-oh, I better get another lawyer to help me with this. And when they get another lawyer involved, and they are clearly in the wrong based on your contract, or, they're committing infringement, usually, their lawyer will point that out to them, because this isn't going to go anywhere. And I like when I get a letter from another lawyer, because usually we can come to a good resolution for my client quicker. So that's going to depend on a lot of different circumstances, but that's kind of how that would play out. In most situations, unless this was like your only client and you were still an independent contractor, but this was like a lot of income you were getting from this one client, a lot of situations, it won't be worthwhile to actually sue them in court. But again, that's really going to depend.
Mm-hmm. Yeah, the legal stuff can be hard to navigate. And I think as online business managers, the critical thing too, I think, is for protecting our businesses, but also being that voice of reason for our clients, and knowing when to say, yes, dear client, you should get that trademarked, or we need to talk to Kailey about this. So Kailey's like a really great lawyer for our clients. So this has been so informative, Kailey. It's such a pleasure always to have you in our community, and to have you, you've always got my back. I really appreciate that. And it means a lot to me. For those of us listening here, we've still got a lot of people on live. We all have clients. They all have their own legal woes, trademark things that they need. How can they get in touch with you, and what kind of OBMs and clients should reach out to you?
Yeah, I have clients that are the whole gamut, product-based businesses, service providers, everything. So you can find me at Kailey Jacomet on Instagram. And then if you would like to book a consultation with me, or your client would like to book a consultation with me because they have questions about their trademark, that's their business name, or a product name, or a program name, or anything like that, or copyright infringement, you can find me at brandlawboutique.com. So you can book a consultation there.
Thank you, Kailey. And I really warmly recommend Kailey. She is professional, on it, knows her stuff, guys. She's the real deal. So Kailey, thank you for always popping in our community and providing your wisdom. You guys know that you can get 30% off. She's offering this to our whole community with the code OBM30. You just need to head over to obmschool.com/legal-bundle to grab either one contract or the entire bundle. You get 30% off. Thank you, Kailey, for joining us today. Thank you, everybody, for being here. Take care, everyone.